West Virginia takes a minimal regulation approach to rent increases that's consistent with the state's overall landlord-friendly posture. If you manage rental property in West Virginia, you have wide latitude to set and raise rent. But as with any state, there are boundaries you need to respect to stay on the right side of the law. West Virginia does not have rent control or rent stabilization of any kind. There is no state statute that limits how much a landlord can increase rent, how frequently increases can occur, or that requires the landlord to justify the amount of an increase to any government agency. West Virginia's legislative history shows no serious movement toward rent control, and the state's political environment makes such legislation unlikely in the foreseeable future. As we discussed in our habitability and lease termination videos, West Virginia does not have a comprehensive residential landlord-tenant act. The landlord-tenant relationship is governed by a combination of West Virginia Code Chapter 37, Article 6, common law principles, and the terms of the lease agreement. This relatively light statutory framework extends to rent increases. There's no detailed statute telling landlords how, when, or by how much they can raise rent. This means that the lease agreement is the most important document governing rent increases in West Virginia. Whatever the lease says about rent amounts, adjustment mechanisms, and notice requirements controls the relationship between the landlord and tenant. A well-drafted lease that addresses rent increases clearly gives both parties certainty and reduces the potential for disputes. For month-to-month tenancies, the landlord can raise the rent by providing advance written notice. Because West Virginia doesn't have a specific statutory provision addressing rent increase notice periods, the general rule is that the landlord must provide notice equal to one rental period, typically 1 full month for a monthly tenancy. This is consistent with the common law principle that changes to the terms of a periodic tenancy require notice equal to the length of the rental period. So if rent is due on the 1st and you want the increase to take effect on April 1st, you need to deliver written notice by March 1st at the latest. The notice should clearly state the current rent, the new rent amount, and the effective date. While West Virginia doesn't require a specific statutory form, putting it in writing is essential for documentation purposes and to avoid any misunderstanding. For fixed-term leases, the rent is locked in for the duration of the lease term. The landlord cannot raise rent during the middle of a fixed-term lease, unless the lease includes a specific provision allowing mid-term increases. Common provisions that permit mid-term increases include escalation clauses, clauses tied to property tax increases, and clauses that allow adjustments based on changes in operating costs. Without such a provision in the lease, the landlord must wait until the lease expires to negotiate a new rent amount. When a fixed-term lease is approaching expiration, the landlord should communicate the proposed new rent as early as possible. If the tenant agrees to the new rate, a new lease or renewal is executed. If the tenant doesn't agree, the lease expires at the end of its term, and the tenant either vacates or the parties continue negotiating. If the tenant stays beyond the lease term without a new agreement and the landlord accepts rent, the tenancy typically converts to a month-to-month arrangement, at which point the landlord can implement increases with proper monthly notice going forward. Now let's discuss the restrictions that apply even in the absence of rent control. Because having no rent cap doesn't mean anything goes. Rent increases cannot be retaliatory. While West Virginia doesn't have a detailed anti-retaliation statute with specific presumption periods and enumerated protected activities like some states, the common law recognizes that a landlord cannot use a rent increase as punishment for a tenant exercising their legal rights. If a tenant reports a housing code violation, makes a habitability complaint, or exercises any other legal right, and the landlord responds with a significant rent increase shortly afterward, the tenant may be able to challenge the increase as retaliatory. Courts evaluating a retaliation claim would look at the totality of the circumstances, the timing of the increase relative to the tenant's protected activity, the magnitude of the increase compared to market rates, and the landlord's history of increases. whether the landlord can demonstrate a legitimate business reason for the increase, and any other evidence of retaliatory intent. Landlords who document their business reasons for each increase and apply increases consistently across comparable units are in the strongest position to defend against retaliation claims. Rent increases cannot be discriminatory. Under the Federal Fair Housing Act and the West Virginia Human Rights Act, found in West Virginia Code Chapter 5, Article 11, landlords cannot raise rent based on a tenant's race, color, religion, national origin, ancestry, sex, age, blindness, disability, or familial status. West Virginia's human rights protections are administered by the West Virginia Human Rights Commission, which investigates complaints and can take enforcement action. Discriminatory rent increases can take several forms. Raising rent for a family with children but not for a single tenant in a comparable unit. Increasing rent for a tenant who develops a disability. Raising rent only for tenants of a particular racial or ethnic background. Any of these actions could result in a fair housing complaint, investigation, and penalties. The best protection against discrimination claims is consistency. Apply the same criteria to all rent increases across comparable units. Document the business justification, market rate data, operating cost increases, property improvements, and keep records showing that increases were applied uniformly. West Virginia's General Consumer Protection Statute, the West Virginia Consumer Credit and Protection Act in Chapter 46A, may also apply to egregious landlord conduct involving rent increases. If a landlord uses deception or fraud in connection with a rent increase, for example, fabricating costs or misrepresenting the reason for the increase, the tenant may have a claim under consumer protection law. From a practical standpoint, West Virginia's rental market is diverse. Charleston, the state capital and largest city, has the state's most active rental market, but even Charleston is small compared to major metropolitan areas in neighboring states. Morgantown, home to West Virginia University, has a tight rental market driven by student demand, and landlords in the Morgantown area can often command higher rents and implement regular increases due to the consistent demand. Huntington, Wheeling, Parkersburg, and other cities each have their own market dynamics influenced by local economic conditions. In many parts of West Virginia, particularly in rural and economically challenged communities, the rental market is softer, and landlords must be strategic about rent increases to avoid vacancies. West Virginia has experienced population decline in many areas, and in communities where tenants have options, aggressive rent increases can result in turnover that's more costly than the additional revenue the increase would have generated. Knowing your local market and pricing competitively is critical. One best practice for West Virginia landlords: build your rent increase strategy into your lease from the beginning. Include clear language about how rent adjustments will be handled at renewal, what notice will be provided, and what factors will be considered in setting the new rate. This gives the tenant expectations from day one and creates a framework that both parties can rely on. In a state where the statute provides minimal guidance, the lease fills in the gaps, and a vague or silent lease can lead to disputes that a well-drafted lease would have prevented. Another best practice: even though West Virginia law doesn't require extensive advance notice for rent increases beyond the 1-month minimum for periodic tenancies, providing more notice for significant increases is smart business. If you're raising rent by more than 5 to 10%, consider providing 60 to 90 days notice. This gives the tenant time to plan and reduces the emotional reaction that often accompanies unexpected financial changes. Good communication reduces turnover, and retaining a reliable tenant at a slightly lower rent is almost always more profitable than dealing with the costs of vacancy, turnover, and finding a new tenant. For landlords who own property near West Virginia University or other educational institutions, the student rental market has its own dynamics. Student leases typically run on an academic calendar, and rent increases are implemented at the beginning of each new lease cycle. Because demand in these areas is driven by enrollment, Landlords can typically implement annual increases that track with the broader market. However, student tenants are also more transient, so landlords in these markets should balance rent increases against the risk of increased vacancy if students choose cheaper alternatives. For the complete guide to West Virginia rent increase laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our landlord-tenant law series.